Today, I'll teach you the chapter 3, the American judicial system, jurisdictions, and venue. There are 11 small issues in this chapter. Learning objective number 1. The law of the judiciary. The law of the judiciary in the context of the American legal system. What is the judiciary? What is the definition of judiciary? Okay, I will tell you, explain you the judiciary concept. Number 2, the difference between the law of federal courts and the law of state courts. Number 3, I will explain the responsibility of trial courts versus the responsibilities of appellate courts. Number 4, I will tell you how the American law are developed by adjudication of cases. Adjudication means judging, rule. Number 5, the difference between the subject matter jurisdictions and personal matter jurisdictions. There are broad 2 types of jurisdictions: subject matter jurisdiction and personal jurisdiction. Number 6, I will tell you when and how in personam jurisdiction and in land jurisdiction may apply personal jurisdiction divided into 2 categories. Personam means personal, land means thing, property. Most American legal terminology come from the Latin word. In them, in personam, come from Latin word. I'll tell you in subsequent slide in detail. Number 8, the federal court has 2 types of subject matter jurisdictions. Federal courts have subject matter jurisdictions over the 2 types of controversies. Under the U.S. Constitution, Section 3 and Section 3 and Article 8. Section 3, Article 8 of U.S. Constitutions provided that federal courts has a power over the only 2 types of jurisdictions. Yeah, I'll tell you in detail in subsequent slide. Number 9, I'll tell you the state law statute state long-arm statute. The law of state long-arm statute that is used for determining the out-of-state personal jurisdictions. Number 10, I'll tell you the minimum context requirement of due process in both traditional personal jurisdictions and personal jurisdictions in electronic business, cyber business, and describe the 3 important ZIFO cases, 3-prong scale. Number 11, I will tell you the special problems posed by a different international jurisdiction standard in the website, in the e-business, okay, in the electronic businesses. Chapter overview. This chapter provides you with the law of American judicial system and structure of the American judicial system and function and authority of state and federal courts. And this chapter describes in detail how the American law developed through court decisions. Number 4, this chapter describes the circumstances when a court has a power to hear the certain controversies, certain cases. Finally, this chapter provides you the determination of the proper and most convenient court location in order to solve the dispute between the both parties, plaintiff parties and dependent parties. The U.S. judicial system. The United States has a federal court system, and each 50 states has each state court system. Therefore, U.S. judicial system is a collection of the federal court and the state court. A U.S. court is set up, is established by the government, U.S. government, to hear the cases and to decide the cases and redress past wrongdoings and redress or prevent the future wrongdoings, redresses past wrongdoing and prevent the future wrongdoings. That is the responsibility of U.S. court. The U.S. court has 2 types of jurisdictions. original jurisdictions and appellate jurisdictions. Trial court has some original jurisdictions. The Court of Appeal and the Supreme Court has an appellate jurisdictions. What is a jurisdictions? A jurisdiction comes from the Latin word juris, means a rule. Diction means speak. The court has a power to rule the cases, rule the matter, and has a power to speak to the both parties. Speak the American rule to the both parties. Okay? Jurisdiction is a power to control, to hear, and to decide, and to impose. Okay? The law of the judiciary. I told you judiciary is a collection of federal courts and the state courts. Judiciary consists of federal courts and state courts. Federal court has 3 levels of courts. State court has 3 levels of courts. Judiciary is a branch of the government which administers the justice, manages the justice according to the U.S. law. There are 2 primary laws for the judiciary, U.S. judiciary. First, law of judiciary is the most important law of the judiciary is to adjudicate this dispute, judging the dispute is the primary law of the judiciary. Second, certain courts, especially U.S. federal courts, are charged with the responsibility of judicial review. A judicial review is the power to review any actions, to review any regulations of the other 2 branches of the government. 2 branches of government are President, U.S. President, and the Congress. U.S. President is the chief of the executive branches. Congress is a legislative branches. And court has a power to declare their actions, their regulations unconstitutional. Therefore, federal court has a power to cancel any regulations, to cancel any actions of the government under the judicial review power. Structures of the judiciary. I told you, judiciary consists of state court and the federal courts. State court adjudicate the matters, the dispute, adjudicate the dispute dealing with cases that is arising from state statutory law, case arising from state common law, cases arising from state constitutional law. State court judging all these matters regarding the state statutory law, state common law, state constitutional law. Federal courts are concerned with the national laws, federal constitutional issues. There are two types of constitutional issues: federal question issues and diversity case issues. I will tell you in detail in subsequent slide. Okay, and federal courts are concerned with other cases that are outside the purview of state courts, outside any matters that is outside the control of state law. Only federal court has a power to regulate those matters. State court. The state court, the majority of court cases, about more than 90% of U.S. cases are filed in the state court instead of federal court. Okay? It means that state court charged on most of the U.S. controversies. Only federal court deals with two types of controversies: federal question controversies, diversity controversies. Except those two controversies, state court deal with all remaining controversies. Or 50 states have two types of courts: state trial courts and state appellate court. State appellate court consists of two courts: Court of Appeal and Supreme Court. Only the Court of Appeal and the Supreme Court has an appellate jurisdictions. State appellate courts are primarily concerned with reviewing the decision of the trial courts. Remember that only appellate court, such as Court of Appeal and the Supreme Court, has a power to set the precedent What is the meaning of president? President means the appellate judge's decision is referred as a president will be a common law, U.S. common law. President has a binding forces over every future cases, future matters, with the similar facts, with the similar the issues, and remember that each state are different from other state as to regarding how the state trial court judges are selected. Some state trial judges, some state judges are selected from the general elections. Some state judges are selected from appointment processes. Some state judges are selected from a combination between the general elections and the appointment process. Next, I will tell you the better courts after the state courts. Better court consists of the U.S. District Court, U.S. Court of Appeal, and U.S. Supreme Court, three different relevant courts. U.S. District Court is similar to the trial court in the state. Similar, U.S. District Court is similar to the state trial court. There are 94 U.S. District Court in the U.S. territory. This U.S. District Court review the issues involving the federal matters, federal issues, and the issues involving the state law when the parties are from different states. It means that two parties are different state residences. In that cases, only federal court has a power to embark. Okay? State court cannot embark into these two different state residence cases. Okay? Second level of federal courts are called as a U.S. Court of Appeal or the Circuit Court. Federal appellate courts are called as the U.S. Court of Appeal or the U.S. Circuit Court. Same meaning. There are 13 U.S. Circuit Courts. The circuit are divided geographically over the U.S. territory, U.S. State, U.S. 50 state, including the U.S. territory, such as the Guam, Guatemala, okay, Hawaii. Therefore, one circuit court deals with the several state matters, judicial matters. You will see the U.S. Circuit geographical location or U.S. Circuit Court in the next slide. Okay? The U.S. Court of Appeal reviewed the decision of Federal District Court, reviewed the decision of the Federal District Court. Or review the several states within each circuit. Finally, U.S. Supreme Court is the final arbiter of the federal law. Okay, this map, this line is the map of the U.S. circuit. There are 12 regional circuits. 94 U.S. judicial district courts are organized into the 12 regional circuits. Circuit is a federal judicial court located in the Washington, D.C. Circuit is a district court circuit located in Washington, D.C. California state are included in the ninth circuit court. Ninth circuit court is located in San Francisco. Okay? Ninth circuit court deals with the California, Nevada state, Arizona state, Oregon state, Washington state, Indiana state, Montana state. Okay? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, and Hawaii and Guam. Okay? U.S. Supreme Court. U.S. Supreme Court is the final arbiter of the federal laws. U.S. Supreme Court consists of 9 justices. Although the court, U.S. Federal Court, has both original jurisdictions and appellate jurisdictions. Federal Supreme Court has 2 jurisdictions, original jurisdictions, such as the federal issue jurisdictions and diversity jurisdictions. In addition to the appellate jurisdictions. Okay? The primary law of the federal court is to finalize the legal decisions on any given cases. I think there are too many legal terminology. These legal terminology are unfamiliar with all the ordinary people because the U.S. legal terminology are come from the ancient England law. Therefore, it can be U.S. legal terminology. It can be very difficult to understand, but you must familiar with this legal terminology in order to operate the business in the U.S. Writ of certiorari. What is the meaning of certiorari? Certiorari is an ancient England king's order. Is referred as a certiorari. Writ is an order. Okay. Writ of certiorari is a discretionary order that is issued by the Supreme Court. For granting the defendant request to argue on appeal. The parties, one parties in the case who are not satisfied with the decision of a lower court must petition the U.S. Supreme Court to hear their cases. In order to petition the U.S. Supreme Court, the right of society must find the right of society. Right of society is a request that Supreme Court order a lower court to send up the record of the cases for review. Unsatisfied party filing for the appeal must file a petition for writ of certiorari. Jurisdictions. Jurisdiction is a court with power to decide a particular cases that is based on who the parties are. There are two parties in the cases, plaintiff party and dependent party. Plaintiff party is a injured party. Damaged party are referred as a plaintiff. Injured is referred as a dependent party. Okay. Jurisdiction is a court's power to decide a particular case based on the parties and the subject matter of the dispute. General jurisdictions versus limited jurisdictions. general jurisdictions. Only trial court has a general jurisdictions. General jurisdiction courts hear the most type of cases, hear the wide variety types of cases. However, limited jurisdictions. Limited jurisdiction court hear any specialized type of cases. Example of limited jurisdiction courts are the tax court, immigration court, traffic court, probate court, family court, bankruptcy court, criminal court, juvenile court, patent court are the example of limited jurisdictions. However, trial court here all type of cases, okay? But limited judicial court can hear only specialized type of cases. Venue. What is the meaning of venue? Venue is a determination defined as determinations choose of the proper court location or determination of the most convenient court location for litigating the dispute. LA County has 59 trial court. Plaintiff can choose the venue for his or her convenience. Generally, proper venue is where the incident occurred. Overview of the jurisdictions. The jurisdictions require a two-part analysis. Subject matter analysis and personal matter analysis. Therefore, a court must have both the subject matter jurisdictions and the personal jurisdictions in order to hear the cases. Subject matter jurisdiction is a court's power over the dispute. Personal jurisdiction is the court's power over the parties. Subject matter means things, controversial. Person, this means two party. granting party and dependent party. Okay. This subject matter jurisdiction is a difficult concept, very, very difficult concept for the beginner, for the students. Jurisdictions over the subject matter. Subject matter jurisdiction is a power of the court to adjudicate the particular type of dispute. Power of the court to judge it, to rule the particular type of dispute, such as bankruptcy, small claim, contract, will, immigration, juvenile matters, contract matters, tort matters, etc. And the power to provide the remedy, to provide the compensations, to provide the money damages demanded. This is subject matter jurisdiction. There are limitations on this type of subject matter cases of court can hear. These subject matter jurisdictions are determined by the federal statute and determined by the state statute. Federal statute is U.S. Constitution's Section 3, Article 8 is a federal statute. State statute is each state has each civil procedure. Civil procedure provide the subject matter jurisdictions. The court, the state court of criminal jurisdictions hear the trials of crimes and misdemeanors. The state court of civil jurisdictions hear and decide the issues concerning the private right, private matters such as the right and duties. Private right and duties. Example, such as the contract, torts. Torts is a wrongdoing against other people, against our society. Is referred as a tort. And civil jurisdiction, court of civil jurisdictions hear and decide the issues concerning the non-criminal public matters, such as the zoning matters, probate matters, residence matters, air pollution matters, traffic matters. Okay? That is the matters deal with the court of civil jurisdictions. I'll tell you the jurisdiction of federal courts after the jurisdiction of state courts. Federal district court has the limited subject matter jurisdictions because according to the U.S. Constitution, Article 3, Section 2, federal court has only two type of subject matter jurisdictions. Federal question cases and diversity citizenship cases. Federal question cases is a dispute that is arised under the U.S. Constitutions, U.S. federal law or regulations. Diversity cases is occurred and the parties, the two parties must be involved in the controversies, in the dispute, in the court, before the court. The two parties are not from the same state. It means that different state residents and the amount in controversy is greater than $75,000. That is the definition of the diversity cases. Okay. Here's the jurisdictions. It is also the different concept. Okay? Jurisdictions of the persons, jurisdictions of the property. Personal jurisdictions divided into two components. Jurisdiction over the persons, jurisdictions of the property. Personal jurisdiction is the power to bring the parties, to catch, to force the parties to the cases into its courtroom to hear the matter. If the party not bring into the courtroom the sheriff or policeman physically force those parties into the courtroom. In addition to the subject matter jurisdictions, the court must have either in personam jurisdiction, in lam jurisdiction. In persona comes from the Latin word. In means over. Persona means person. Personally, in personam jurisdictions require that dependent must be a residence of the physical boundary of a court authority, and dependent must be located within the physical boundary of court authority, and dependent must have committed the wrongdoing within the physical boundaries of court authority. In that cases, the court has the personal jurisdictions or the dependent of the person. In them, jurisdictions come from the Latin word. In means over. Then means thing. thing include everything, especially thing include the property, and thing include the marriage. Marriage is a kind of thing, land, property, personal property, real property is a land. In them, jurisdictions apply when the property, personal property, real property, that is the subject of the dispute, is located within the physical boundaries of court authority, court of power. Example of in land jurisdictions is a dispute, controversy, fight over the house sale. The dispute of a house sale is an example of in land jurisdictions. Oh. When the dependent is out of state residence, how can we do? That is the state long arm statute matters. New terminology, long arm statute. Or the jurisdictions or with the out of state dependent state long arm statute. Assume that Nevada state residents visited California and the damaged California property. In that case, California court has a power to catch the Nevada state residents into the California state court based on the California long arm statute. For the jurisdictions of the out of state dependent, each state long arm statute are used for non-resident parties based on the means requirement of due process with the state. Therefore, in order to apply the personal jurisdictions over the out of state dependents, two components are required. First requirement is a state long arm statute. Second component requirement is a minimum context test. Difficult concept, okay? Because the U.S. government, U.S. United States of America, consists of 50 different states. Each state has a different law, okay? Therefore, different state residents, but in the cases, state long arm statutes are used for the non-resident parties. Okay? The courts jurisdictions must be authorized by a state long arm statute, and the court must ensure that exercise the jurisdictions of out-of-state dependent meet constitutional requirement of fairness and due process. Constitutional requirement of fairness and due process is referred as a minimum contact with the forum state. Minimum state dependent minimum contact with the forum state is the requirement of the due process and fairness. A minimum context test. In order to apply the minimum context test, the court must find that defendant, out-of-state defendant, must purposefully avail themselves with the forum state. This is the landmark cases for the minimum contact to test. Under the estate of Bain Garrett cases, the Third Circuit Court held that as follows. This is a third court's decision. It is clear that the critical finding is that dependent purposefully availed itself of the privileges of conducting activities within the forum require contacts that amount to deliberated, intentional reaching into the forum state to target these decisions. Okay? Therefore, in order to apply the personal jurisdiction over out-of-state dependent, minimum context test must be required. Forum selection. Forum selection is a predetermined propose two parties that determines the location and determines the court here the legal dispute will be settled. In the insurance contract, this following statement is a mandatory. This statement, forum selection, must be included in the insurance contract. In the event of any dispute that arises from the performance, breach, or any obligations under this contract, the parties agree to litigate any such dispute in the State Court of California as the exclusive venue, and both parties hereby voluntarily submit to the exclusive jurisdiction of the matter. There is a forum selection arrangement that is included in the contract. Venue. Venue is a legal concept. I already told you the venue, the concept of venue. The determination of most convenient court location, is a venue. Typically, state statute provide that the venue in the civil cases is where the dependent decide dependently, where the dependently or where the dependent company is headquartered. In the criminal cases, the venue is ordinarily determined where the crime, the wrongdoing is committed. Okay, we are almost. Jurisdictions in the cyberspaces, jurisdiction in the electronic business, minimum contacts of the internet. In order to apply the minimum contacts over the internet, the U.S. court apply the ZIPO standard, ZIPO case standard. The Supreme Court, U.S. Federal Supreme Court, for the ZIPO cases in 1997, the Supreme Court established, set up a three-pronged test for determining whether a venue, a court, has a jurisdiction of a website or not. If the court passes the three-prong test, ZIPO prong test, that court has a jurisdiction over the internet business, internet. Under this ZIPO standard, there are three types of internet business contacts. First prong test, substantial business of the internet. Second prong test, interactive activities through a website. Third prong test, passive advertising, passive upload the advertise and upload the information through the website. Okay? These three types of internet business contact is important for applying the minimum contact with the foreign state or the electronic businesses. Email contacts and minimum contacts. This email and minimum contacts may be for the personal jurisdiction may be based on the one party's use of internet and email in his business. Under the Supreme Court, the decision email communications between the both parties with ongoing business relationship has been null sufficient minimum context by a limited number of courts. Okay. Okay, international jurisdictions for internet transactions. Recently, the US, United States of America, and Canada, and European Union has generally agreed to apply the law of the country where the dependent servers are located. It means that forum state must be the court where the dependent servers are located. That is so-called as a country of origin principle, or a country of origin standard. Under the country of origin principle, in international web transactions, generally, the court in the location of website servers will have the jurisdictions of any dispute that is arising out of use of website. That is the common rule of country of origin approaches for international internet transactions. However, there are exceptions to the general rules. Some countries have adopted the country of deception approaches instead of country of original approaches. This increased the risk to the business because, in theory, that both parties, the plaintiff, must need to have a fundamental knowledge of the laws of each individual country. It is very difficult, sometimes impossible. Therefore, some country adopted the country of reception approach instead of country of origin approaches. Okay, last slide. Other theories of jurisdiction in electronic commerce. The Australia's highest court, Supreme Court, in 2002 ruled that the American-based published Dow Jones could be sued in Australia for defamation based on an article that appeared on its Dow Jones, American company Dow Jones' website. Australian Supreme Court ruled that even though American company Dow Jones has not appeared in Australia, has no presence in Australia, and its website and infrastructures are located in New Jersey. However, Australia court has a power over the U.S., the Dow Jones dependent company, Dow Jones. Okay, these are the current important issues in the electronic commerce.